Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today what I'm going to talk about are interrogatories, which are written questions directed to an opposing party, asking that they provide responses to those questions, which are questions related to the underlying case, so divorce or custody case. It's asking them to provide responses to those questions under oath, and those responses are provided in written form. Now, interrogatories and responses to interrogatories, they're not super common in family law cases. They're not used very often, but I think they're an underutilized resource that one can definitely use in a family law case. And the reason they're not really used is depositions are more common, which is an in-person, interrogation of maybe interrogation is a bit of a strong word, but it's an in-person questioning of the opposing party. And people often prefer a deposition over interrogatories because depending on what the answer is, you can ask follow-up questions and you can take, several paths down different rabbit holes if you want to know more about a certain subject, which obviously is very difficult to do if you're asking written questions because you don't know what the response is going to be in advance. So that's probably the reason that they're not used all that much, because it becomes difficult to ask follow-up questions. But you might want to use them in, a very simple case where your client doesn't have or you or your client do not have the financial resources to take a deposition. Deposition can be expensive. Or maybe you've already taken a deposition, you just have one or two follow-up questions that you forgot to ask at the deposition. You can submit written interrogatories in lieu of doing a second deposition. So I'm going to start by going over the Connecticut practice book sections that are relevant to interrogatories. So let's share my screen. I'm not going to go over the whole sections. I've highlighted kind of the key provisions. So Connecticut practice book section 13-6 is, the general section relating to interrogatories. And it says that in any civil action, any party may serve written interrogatories upon any other party to be answered by the party served. So, you put together these written interrogatories and you serve them on the other party. And those interrogatories may relate to any matters which can be inquired into under section 13-2/13-5. So those are the discovery sections of the practice book. And the answers may be used at trial to the extent permitted by the rules of evidence. And I'll talk a little bit later about how these interrogatories are used. So basically, you can ask questions on any subjects relating to the case. The other party may object, and we'll talk about that a little bit more. And then the serving party or the party serving interrogatories or the notice of interrogatories shall not file them with the court. So you don't have to file the actual interrogatories, although I do like to file a notice of interrogatories that tells the court that you put together interrogatories, which I'll show you momentarily. 13-7 of the Connecticut practice book talks about answers to interrogatories. So any such interrogatory shall be answered under oath by the party to whom directed, and such answers shall not be filed with the court, but shall be served within 60 days after the date of certification of service. So you have 60 days to answer interrogatories. And you may have more or less than 60 days if, counsel file with the court a written stipulation extending the time within which to answer interrogatories. So you can extend it by agreement, or you can file a motion asking for the court to extend the time if you don't want to do it within the 60 days. And then, if you're filing an objection, you don't have to file an answer, but the objections to interrogatories and the reason for the objection are, have to be filed within 60 days. And as long as you file that objection, you don't have to answer the interrogatory that you're objecting to. All answers to interrogatories shall repeat immediately before each answer, the interrogatory being answered, and be signed by the person making them. So I'll show you this in a sample. A party objecting to one or more interrogatories shall file an objection in accordance with practice book section 13-8, which we're going to go over momentarily. Objection by a party to certain of the interrogatories directed to such party shall not relieve the party of the obligation to answer the interrogatories to which he or she has not objected within the 60-day period. So you still have to answer the interrogatories that you don't object to. The party serving interrogatories or the notice of interrogatories may move for an order under section 13-14 with respect to any failure to answer. So you can basically file a motion to compel if the opposing party does not file an answer. Let's move on to section 13-8 of the Connecticut Practice Book. This deals with the objection. So the party objecting to any interrogatory shall set forth each interrogatory that they object to, specifically state the reason for the objection, and state whether any responsive information is being withheld on the basis of the stated objection. Objection shall be filed with the court pursuant to 13-7. So you don't file your responses. The only thing you file with the court are objections to interrogatories. All right, so let's look at sample interrogatories. So here, it's just, obviously you put the regular caption in the case, you put that it's, here it's the defendant, their first set of interrogatories. The defendant in the above referenced matter pursuant to the Connecticut Practice Book requests that the plaintiff answer the following interrogatories. Answers to the following interrogatories will directly assist the defendant in the preparation and proving of the above captioned case. So it says, by way of interrogatories, do you believe your marriage to be irretrievably broken down? So these are just examples of interrogatories that you may, ask the opposing party. If your response to the previous answer was in the affirmative, why do you believe your marriage has irretrievably broken down? Do you believe that any conduct on the part of your spouse contributed to the breakdown of your marriage? If your answer was yes, basically, what do you feel that they did? So I don't need to go over every one of these. This is just the general format. It's question, and you put answer in a blank space within which they can provide their answer. And it's a general courtesy when I file these. I also, or when I serve a PDF copy, that's what you're supposed to serve, but I also send a courtesy Word document so that the other party has the Word document to make their, to fill in their answers. So you put all those inquiries with the answer, and then obviously you sign it and put your certification of service. So that's the interrogatory. And then here's a notice of service of interrogatories. So just to let the court know that you filed interrogatories or served the other party with interrogatories so that they are on record. And then you have to file, if you object to anything, you have to, that is something you do file with the court. So here is a sample of that. It's plaintiff's objections to defendant's first set of interrogatories, and then you insert the date of the request. And then, you put the actual interrogatory. So in this example is, what discussions have you and your attorney had relating to the amount of alimony you're seeking in this divorce? So, conversations between you and your attorney, those are privileged, with which, you are not obligated to turn over that information. So here the objection is that the plaintiff objects on the grounds that the defendant is seeking the disclosure of privileged information. And then you're also required to state that the plaintiff is withholding responsive information based on this objection. Because if you remember, the objection section of the practice book states that you have to indicate whether or not you're withholding any responsive information. And then obviously you sign that objection, put the certification of service or certificate of service, and you file that with the court. So those are sample objections. And then I'm going to finally show you sample responses. So, you just put a caption on the case that indicates that they are the responses to the interrogatories. And then, you just write out that below are the responses to the interrogatories. And then, you just write out each individual question that was asked of you. And then in the answer, you just, you fill out your answers. In this sample document, I was pretty brief in the answers, but you want to be reasonably thorough in your responses. If they're asking what you believe why you believe your marriage broke down, you want to be as thorough as you would be at trial in explaining your case. And, same with, listing anything you feel that your spouse did or you did to contribute to the breakdown of your marriage. So you want to, you want to be thorough in your responses, but, don't go above and beyond and provide information that was not asked for. You want to specifically answer the questions that have been asked. And then if anything was objected to, you just, put that you objected to, the reason for your objection. Again, it's not sufficient to only put your objection in the interrogatory response. You have to also file that objection. And then again, these have to be sworn to under oath by the person who is responding. So you want to put the client's name along with, a part here where a notary or a commissioner of the court can notarize the document so that it can be sworn to under oath. And then you put the certificate of service. And again, these responses are not filed with the court. They are simply provided to the opposing party. So those are the basics on interrogatories. Now, as far as how they are used in family court, obviously they're used to gather information. So if you get this information, you have it so that you know what additional information you might want to pursue, or, it allows you to understand what the opposing party is going to ask at trial. One of the common rules of thumb is you don't want to ask any questions of the opposing party at trial that you don't already know the answer to. So you want to know what they feel the cause of the breakdown of the marriage is in advance. So you will use it to gather information. And then, if at the time of trial, the opposing party answers a question that you asked in an inconsistent way. So in a manner, if their answer is inconsistent with their response to the written interrogatory that they had provided, with their response to the interrogatory, you can then use that written response to cross-examine them at trial. So, if they testify at trial that, the cause of the breakdown of the marriage was that their spouse was physically abusive, and they did not put the physical abuse in the interrogatory, maybe they just, said that they just weren't getting along anymore. But you can then, cross-examine them, say, show you this document. Do you recognize this document? This is a copy of your interrogatory responses dated so and so a date. In this interrogatory, I asked you what you believe the cause of the breakdown in the marriage is. And in that response, you, in fact, did not say that that my client physically abused you. Isn't that correct? So, this is new information that you never provided in the past. So, you can use those documents to cross-examine them and, impeach their credibility, make them seem like they're making things up with the court. So again, those are the basics of interrogatories and how they're used in family court. As usual, if you have any questions, feel free to call our office at any time.